Just give me one moment. I am very pleased to rise to speak in support of Bill S-272, an act to amend the Director of Public Prosecutions Act, and remind colleagues that this is a companion piece of legislation paired with S-271, an act to amend the Royal Canadian Mounted Police Act, to which I just spoke. As these two bills are closely intertwined, I refer all senators to my more comprehensive speech, as I hope my comments will be brief. Again, I urge all senators to review Senator McCollum's twin speeches on these bills. In 2021, the House of Commons Indigenous and Northern Affairs Committee, INAN, led an in-depth study on enforcement on First Nations Reserve as an essential component to their self-government and self-determination, addressing A, jurisdiction, enforcement, and prosecution, B, targeted funding for enforcement, C, the First Nations Land Management Act, D, First Nations debt certificate processing, E, the prosecution of First Nations violation tickets, F, enforcement agreements with policing agents, G, enforcement capacity development. The committee was conclusive in assessing that First Nations face barriers in having their laws and bylaws enforced. The committee report, tabled in the other place in June 2021, made 10 recommendations to government focused on the urgent need to address the lack of enforcement of First Nations laws and bylaws. Notably, the recommendations presented in the report aimed at moving this issue forward in the short term, recognizing that in many cases, longer-term solutions are still required. Please note, over the course of recent decades, various pieces of modernizing amendments to the Indian Act have been introduced, all intended to further the self-governance and law-making authority of First Nations. These include landmark legislation such as C-49 in 1999, the First Nations Land Management Act, which was replaced by the more comprehensive 2022 Framework Agreement on First Nation Land Management Act. The Framework Agreement expanded the range of autonomous powers that First Nations could exercise, removing the need for approval from the Governor and Council or Minister. Under the Framework Agreement, a First Nation is empowered to create an independent land code that outlines how the community will work together to develop laws and policies for governing and managing their reserve lands and resources. Another key piece of legislation was Bill C-428, the Indian Act Amendment and Replacement Act of 2014, which eliminated the prerequisite for the minister's oversight in regard to the submission, coming into force, and disallowance of bylaws, which is to say, it granted to First Nations the autonomy and responsibility.
I'm sorry, Senator McPhedran. Sorry, but it is now 4 o'clock. Il est maintenant 16 heures.
It is now 4 p.m. and pursuant to the order adopted on September 21st, 2022, I declare the Senate adjourned to Thursday, December 5th, 2024 at 2 p.m. The Senate so decreeing.
Senator McPhedran.
Thank you very much, Your Honour. Appreciate the opportunity to complete my speech from yesterday. I'll try not to repeat too much of what I did say yesterday. Sorry, just give me. Honourable Senators, I'm pleased to continue my remarks in support of Bill S-272, an act to amend the Director of Public Prosecutions Act. This bill links with S-271, an act to amend the Royal Canadian Mounted Police Act, to which I spoke yesterday. These bills would strengthen First Nations self-governance and resolve some long-standing legal and technical barriers to effective enforcement of First Nations laws and bylaws, which are enacted at the local level to protect their peoples and foster communities safer for their citizens, especially their children. Unfortunately, despite the intent of Parliament to enhance the self-determining lawmaking powers of First Nations, unintended consequences emanating from some of these bills, for example, C-49, the Framework Agreement on First Nation Land Management Act, and Bill C-428, the Indian Act Amendment and Replacement Act of 2014, have created what have come to be called, quote, stranded regimes, quote, of First Nation laws that are not enforced by the RCMP nor prosecuted by the Public Prosecution Service of Canada. Chief Keith Blake of the Indigenous Land Advisory Board, which represents more than 100 First Nations who have enacted land codes, adroitly sums up the jurisdictional crisis, and I quote, "Most jurisdictions across the country do not recognize or prosecute nation-legislated offenses. The challenge most Indigenous communities face in this country is the refusal or the reluctance to have provincial Crown prosecutors or federal prosecutors undertake the prosecution of these nation legislation cases," end of quote. As illustrated in my earlier remarks on S-271, the causes and obstacles to proper, safe, and equitable enforcement of First Nation laws are myriad. But two principal impediments to enforcement of First Nations law, identified in the other place by the Inan Parliamentary Committee, are lack of enforcement by police services and near total absence of prosecution in the courts. Indigenous law expert Nick Sousan draws clear conclusions, and I quote, "From the perspective of a police force when facing a request to enforce a forced removal from a reserve, the police chief or detachment commander must consider whether it wishes to allocate the time and resources to a law that has no chance of implementation because there is no provincial territorial court that recognizes it. Many police forces view Indian Act bylaws as not having the same legitimacy as federal, provincial, territorial, or municipal law, and as not being worth the liability risk and resource expense required to enforce them," end of quote. Prosecution of federal laws falls under the remit of the Public Prosecution Service of Canada, PPSC, a national, independent, and accountable prosecuting authority whose main objective is to prosecute federal offenses and provide legal advice and assistance to law enforcement. During its study of this issue, the House of Commons Committee was informed by PPSC officials that they only prosecute bylaws that have been officially reviewed. Specific to First Nations, PPSC only reviews laws under the Indian Act. The purpose of such a review, to check for compliance of the Charter and Rights and Freedoms, is supposed to be conducted. This is ironic, considering that not all sections of the Indian Act itself are compliant with the Charter. Following the removal of the minister's power to disallow a bylaw in 2014, First Nations laws need not be submitted anymore to the minister for approval. So PPSC stated that it also, by consequence, removed mandatory departmental review of First Nations land code laws. So it just isn't done anymore. And that has led to the lack of enforcement and lack of prosecution of laws enacted by First Nations. Chief Keith Blake adroitly sums up the catch-22, quote, "The challenge most Indigenous communities face in this country is the refusal or the reluctance to have provincial Crown prosecutors or federal prosecutors undertake the prosecution of these nation legislation cases." In moving this legislation, Senator McCollum explained how Bill S-272 is necessary to clarify and conclusively confirm that the Public Prosecution Service of Canada has the jurisdiction and the mandate to initiate and conduct prosecutions of summary conviction offences under First Nation law, as well as any appeal or other proceeding related to such a prosecution on behalf of the First Nation that made or enacted that law. Bill S-272 will amend the Director of Public Prosecutions Act to include the following definition of First Nation law. A bylaw made under the Indian Act. B, a First Nation law is defined in subsection 2.1 of the Framework Agreement on First Nation Land Management Act. Or C, a law enacted by a council, government, or other entity that is authorized to act on behalf of a First Nation under a self-government agreement implemented by an Act of Parliament. Law enforcement and prosecutors are two separate entities of our justice system that directly impact one another and must rely on each other to carry out their objectives in an interdependent relationship. But this model has failed First Nations for generations. The current dysfunction that has resulted in the stranded regimes of First Nations law is but another tragic failure that Parliament did not intend. But it's a big mess that Parliament must fix because it is costing Indigenous lives. Before I speak on more technical aspects of this bill, please join me in widening our contextual lens to reach across the street outside this chamber to the annual winter meeting of the Assembly of First Nations in session for its final day this year. Since August, just months ago, 10 First Nations people have been killed by police. On Monday, National Chief Cindy Woodhouse-Nepinak called for, and the Assembly on Tuesday passed, a resolution demanding Canada call a national inquiry into systemic racism in policing to address what they're calling, quote, one interrelated epidemic of violence and death. This epidemic likely began at the community level, where First Nation laws enacted by First Nation leaders to protect their communities is now seldom enforced or prosecuted. Both logic and evidence should prompt us as parliamentarians to listen to these leaders when they have made it so clear that they need Bills S-271 and 272 to protect their communities, especially their children. As with Bill S-271, amendments in S-272 provide a level of needed clarity and can serve to loosen interjurisdictional blockage, enhance coordination between the enforcement and prosecutorial arms of our justice system, and open a space for deeper dialogue between First Nations and governments to seek more permanent and comprehensive solutions to this lamentable situation. With appreciation to Michael Anderson, consultant to the MKO, please allow me to summarize what is at stake here. Although a bylaw enacted by a chief and council pursuant to sections 81.1 and 85.1 of the Indian Act is one of the, quote, laws of Canada, quote, and thus a matter clearly under the jurisdiction of the Attorney General, the Chief Federal Prosecutor in Manitoba advised the MKO First Nations on June 1, 2023, that bylaws enacted pursuant to the Indian Act had not been enforced in Manitoba for 30 years, and by implication not prosecuted. With the repeal by Parliament of the ministerial power of disallowance through the coming into force of the Indian Act Amendment and Replacement Act in 2014, all Indian Act bylaws enacted after December 16, 2014 are first presumed by police and prosecutorial authorities to be statutorily invalid and charter non-compliant, as there is no longer any, quote, appropriate federal authority, quote, to review and potentially to confirm or disallow a bylaw. Thus, although the sponsor of Bill C-48, the Indian Act Amendment and Replacement Act, described the purpose of the bill as supporting the self-determining lawmaking powers of First Nations, this is the legislation that in fact created the stranded regimes of First Nations law. Earlier yesterday, Mr. Anderson reminded me that MKO takes the position that the refusal of police to enforce and the refusal of prosecutors to prosecute Indian Act bylaws that have been enacted following the coming into force of the Indian Act Amendment and Replacement Act amounts to police and government prosecutorial officials mindfully acting to frustrate the will of Parliament. It is also MKO's assessment that the lawmaking powers of First Nations pursuant to Bill C-61, the First Nation Clean Water Act, and Bill C-92, which senators will recall well, an act respecting First Nations, Inuit, and Métis children, youth, and families, will similarly result in more stranded regimes of laws enacted by First Nations that are not recognized by police as enforceable and are not recognized by Crown prosecutors as being subject to prosecution. It is to address and resolve the foundational reasons for these stranded regimes of First Nations laws that Bills 271 and 272 are directed. Honourable Senators, I invite you to move this bill to committee along with S-271. They are both worthy of more thorough study with the skills and care that Senators can bring to much-needed legal changes to respect and support First Nations sovereignty in protecting their communities and their citizens, including their children and youth. Thank you. Merci. Miigwech.
I'm sorry, honourable senators. Well, there's 30 seconds. So, Senatrice Audat, you were first, but 30 seconds.
Merci beaucoup, Madame la Sénatrice. Vous savez que...
Thank you very much, Madam Senator. The Supreme Court had made a ruling about Indigenous police. Do you think that this will demonstrate that Indigenous peoples should get the powers that they deserve?
McPhedran, few minutes. Few seconds, sorry.
2 seconds?
Few seconds.
Je suis d'accord.
I agree.
Time has expired.